One important factor while we are discussing the arbitration agreement and drafting an arbitration agreement is the concept of seat and venue. So when I say seat and venue, many a times, many clients confuse this or use it interchangeably, seat with venue. It's an incorrect understanding. A seat is very different from the concept of a venue. Seat A seat of arbitration gives the particular court of that jurisdiction an exclusive jurisdiction. So, for example, if you select a seat in Mumbai for a particular arbitration, the Bombay High Court, that is, will have exclusive jurisdiction for all the proceedings which arise out of the arbitration, be it your claim for interim release under Section 9 or a challenge to an arbitral award. Whereas venue is a place where parties or the arbitrators can decide to meet. It can be a place of convenience for all parties involved. In many cases, what happens, parties fail to mention the seat of arbitration but mention venue. In those cases, depending upon the circumstances of that particular case, a venue can be an indicator to a seat. But having said that, I would still maintain that while drafting an arbitration agreement, it becomes extremely vital to clearly mention the seat of arbitration. Now, the seat as a concept does not find mention in Section 20 of the Arbitration and Conciliation Act. So, I would say it is a judge-evolved law. And when I say a judge-evolved law, it is evolved by virtue of judgments passed in this regard. Several judgments have been passed to clarify the importance and the meaning of the word seat. So apart from its contractual scope, a seat, really speaking, becomes very important in a case when you should understand what a final goal for the client is. So when a client approaches you in case of an international commercial arbitration, while guiding the client or while drafting an arbitration agreement in order to decipher what the seat of arbitration would be, various factors need to be considered. One of them is trying to ascertain the assets of the other side, where they are based. It is more from the perspective of getting any kind of interim release against that party or enforcing the award at the end of the day. So the substantial assets of the party and its location also become an indicator for deciding a seat of arbitration. In case of an international commercial arbitration taking place outside India, where the seat is outside India, or you've decided that the seat is outside India, one important factor to be considered is where a party to arbitration or parties to arbitration want to expressly exclude Indian court's jurisdiction in the arbitral proceedings. It is advisable, more so considering the recent amendments, the 2015 amendments to Section 2.2 of the Arbitration Act, that it is expressly mentioned that the provisions of Section 9 and 27 of the Arbitration and Conciliation Act stand excluded. So in this event, we as a guiding factor while drafting an arbitration agreement have a model clause for y'all, in which the parties have expressly excluded the operation of Part 1 and more so Section 9 and 27 of the Arbitration and Conciliation Act. So the model clause reads as, the parties agree that the provisions of Part 1 of the Arbitration and Conciliation Act, including specifically but not limited to the provisions of Section 9, 27 and Clause A of subsection 1 and subsection 3 of Section 37 stand excluded and shall not apply to this agreement. It is also important to note that there is certain ambiguity on law as to a right of two Indian parties adopting a seat outside India. While the Gujarat High Court and the Delhi High Court have ruled in favor of the right of two Indian parties having a right to opt for seat outside India, the Bombay High Court has taken a contrary view. But as far as the Supreme Court of India is concerned, the Supreme Court is still in the process of crystallizing the law in this regard.